What crimes cannot be pardoned by the Canadian Parole Board in Canada? Well, first of all, it's not called a pardon anymore. It's called a record suspension. I do another video on that particular topic. So there's different scenarios where you're not eligible for a pardon, and I'm just going to go through those with you here today. So first of all, if you've served 3 different sentences in the penitentiary of 2 years or more, so let's say you had a sexual assault conviction, you served 3 years, an aggravated assault, you served 5, and let's say you did a manslaughter for 7 years, you would not be eligible for a pardon. That's the step 1, okay, and that's the first caveat. Secondly, and this makes perfect sense, you're not eligible for a record suspension if you committed a sexual assault against a minor. That's very important. We don't want people getting record suspensions when we know that they're potentially a pedophile. So we keep that record on the Canadian CPIC system. Now, there's an exception to that. There's a narrow exception you can apply to the parole board if you convince them that you were not in a position of trust or authority for that child, if you didn't use any coercion, intimidation, or physical violence, and you were less than 5 years older than them, then you may be able to get that exception, but that's a very narrow exception. The final matter where you can't get a pardon, if you have a life sentence, for example, if you've been convicted of murder, even after you're paroled, that's a life sentence, so that can't be pardoned. And the other's when you have what's called an indeterminate sentence. So that means, for example, dangerous offenders, they're in jail forever. It's kind of indeterminate jail term, so you can't get a pardon in that particular scenario. So everyone else can at least apply for a pardon. It's within the discretion of the parole board. It's a fairly involved process, but I encourage people who do have criminal records who are eligible to apply if it's a summary conviction offense after 5 years from the date of sentence. And if it's an indictable offense, you should apply 10 years after the date of sentence. But start your application process a little early because there's quite a waiting time and list. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.